All right. Good morning. You can be seated. We're here before the court on State of Ohio versus Rhonda Pasek, P-A-S-E-K, 16 CRB as in beta 01737. Regards to this matter, Ms. Pasek, you are here on a child endangering charge under Ohio Revised Code 2919.22a. It's a misdemeanor of the first degree. This carries anywhere up to 6 months in jail, up to a $1,000 fine. Do you understand what you're charged with and the range of punishment that you face?
Yes, Your Honor.
Now, did you also receive a copy of the complaint that was signed by the police officer, Officer Thompson, that informed you of the charge and also the facts that would be presented against you at a trial or jury trial if that would have occurred? Did you receive a copy of your complaint?
Yes, Your Honor.
Did you read and understand that complaint?
Yes, Your Honor.
Also, Ms. Pasek, in regards to this matter, you were provided written constitutional rights. They're very much the same as the verbal constitutional rights I went over with you at the time of your arraignment. Did you have an opportunity to read those rights and to understand those rights?
Yes, Your Honor.
And did you also have an opportunity to confer with your court-appointed attorney, Attorney Algiers, to go over those rights, what you were charged with, and your range of punishment?
Yes, Your Honor.
Okay, Ms. Pasek, I've been informed that you intend to plead this morning. I do want to confirm with you that a guilty or a no contest plea is exactly the same as pleading guilty for today's purposes. A no contest plea is essentially an admission of the elements of the crime of child endangering. You would be found guilty. You would receive your punishment without any witnesses or evidence being presented either against you beyond a reasonable doubt, which is the burden of the state, or for you to have any opportunity to defend. A no contest plea may or may not be able to be used against you as a repeat criminal offender. It stays here if you sued civilly as a result of this incident. However, as opposed to a guilty plea, which can be used against you in all other courts of law. But a guilty plea equals a no contest plea equals a finding of guilty. Do you understand?
Yes.
All right, for this morning, Attorney Gamble is representing the prosecutor's office. Attorney Algiers is appearing on behalf of Ms. Pasek as defense counsel in 16 CRB 1737 on September the 15th. Attorney Algiers, I will hear from you in regards to count 1, the child endangering charge.
Thank you, Your Honor. My client will withdraw her former plea of not guilty, enter a plea of no contest, stipulate to a finding of guilt, and waive the introduction of evidence. Let the record reflect that she has, in open court and writing, waived her right to a jury trial.
Thank you. I find that Ms. Pasek knowingly and voluntarily has waived her right to jury trial in regards to this matter. She fully understands the laws of the state of Ohio and her constitutional right to a jury trial. I will accept her no contest plea, which is a full admission to the elements of child endangering. I will make a finding of guilty in regards to this matter. had an opportunity to review the police reports as well as the extensive fact pattern that was located on the complaint that Ms. Pasek indicates that she received a copy thereof, has read it, understood it, and had an opportunity to review it with her attorney, Attorney Algiers. All right, at this time, Attorney Gamble, I believe that you have a plea agreement that's been executed between yourself, Attorney Algiers, and the defendant, Ms. Pasek.
Yes, Your Honor. Respectfully, the state is recommending that on the charge of endangering children that the court impose the maximum sentence of 180 days in a county jail. It's my understanding she also intends to enter pleas of guilty or no contest to the disorderly conduct intoxication charge as well as the seatbelt charge. On the disorderly conduct charge, the state is asking that the court consider imposing a fine of $150 in the cost of the action. On the seatbelt charge, recommending a fine of $30 in the cost of the action, recommending that those fines be served consecutively for an aggregate recommendation of $180.
All right, in regards to this matter, I have had an opportunity to review the case, and I do find, Ms. Pasek, that this case does garner the maximum penalty that this court can give you under Ohio law. So you will have 180 days in jail in regards to this matter. As in regards to your fine, in regards to your child endangering, at this point in time, that fine will be a $280 fine. It'll be concurrent. Your jail sentence will be imposed. You will begin to serve that at the minimum security misdemeanor in jail, the county jail. You'll have credit for time served. I do remind you that it's 24 hours in one day, so that you will be serving 180 24-hour days. You'll have full credit from the time that you were booked into the county jail. That's when your jail time will start. Now, in regards to this matter, given the fact that there may be other pending charges, of course, in regards to this matter, the items that would have been seized in this are just going to be preserved at this time. Is that correct? Any items that were seized during the course of this stop?
I presume that they remain in the custody of the police department, except as they may have been transported for further analysis.
Fine. As to the seatbelt violation in regards to that matter, as a passenger, that is a standard $20 fine, and then you have your court cost on that as well. In regards to that matter, is your client going to be entering a plea to that?
Yes, Your Honor. My client will enter a plea of guilty to that charge.
That's the fine of $20 as set by Ohio law. Your court costs are $63. These fines will be concurrent. And that is in case file 16 TRD 01741. Now, as to the disorderly conduct charge, count 2 and 16 CRB 1737, 291711B1, minor misdemeanor, maximum penalty of up to $150 fine, and court cost, if any. Attorney Algiers, I will hear from you.
Thank you, Your Honor. My client will enter a plea of no contest to that, stipulate to a finding of guilt, and waive the introduction of evidence.
Given the fact that Ms. Pasek does not live in the state of Ohio, she has a lengthy jail sentence of 6 months, which is 180 days, and she's indicated that her sole source of income is Social Security and food stamps. In regards to this matter, her fines and costs will go to the Attorney General of the state of Ohio, which is the individual that collects all of the fines and costs on behalf of the court where appropriate. And I find that it is appropriate for that to be done. He would have more success with able to collect those than perhaps the court would in this particular case for the reasons that I have detailed. Now, in regards to this matter, Ms. Pasek, are you currently living at 1684 Mayhew Road, New Cumberland, West Virginia?
Yes.
The bailiff will present the copies of the judgment entries to Ms. Pasek and her attorney. Attorney Gamble, would you also care for a copy?
I would ask that the court provide copies to Attorney McNichol in my absence.
Well, I'll be happy to do that. Thank you. I would ask your cooperation. We have a number of cases. We have individuals that are coming to the court for other business, as well as probationers. If you could please remain where you're seated until the bailiff can direct you so that we can make sure this building was built in 1938. It was a works project. It served us well and this community well. However, we do have a number of individuals using the same egress and ingress. So I would ask your help while we make sure that everyone is removed from the courtroom in a very timely and safe manner. Thank you.
Thank you.
When they clean up.